Mark. As soon as I saw this one, Matt, I could feel your inner child screaming on this one. Can they come back and get more later?
No, Kenny, generally not.
Right.
No, when an insurance company sends you a check, what they do, they'll send a release with that. So no, you cannot settle it allow, come back later. So you got to be very careful with that. So absolutely not. So let me also kind of mention, now is a good time to check your uninsured motorist coverage.
Right.
Now, we talk about this every year about this time, and I'll continue to talk about it because I have clients that come in still every day, still not very kind of sure about how this works. But it is the coverage that you can get to protect yourself, meaning that when you get insurance, everyone focuses on like $25.50 is the state minimum. That's the amount of insurance that pays out if you cause an accident. Well, the important thing, and most of the time, is what type of insurance do you get if someone else hits you, if someone else doesn't have, has low insurance or no insurance. So that's uninsured motorist coverage, and that coverage and your own insurance company will actually pay you if you're in an accident by someone else's negligence. So, and another chilling fact, Kenny, I heard this week is that in the state of Mississippi, if you're in an accident, you have a 30 to 40% chance the other person does not have any insurance at all.
Wow.
No insurance at all. So in that kind of case, uninsured motorist coverage becomes critical. Absolutely.
Well, and let me throw this one out. We're talking about personal experience. It's the underinsured. So maybe they have insurance on the paper card that they hand to the officer that night, but it is underinsured at the most. And that one got me about a year ago.
Absolutely. So. And let's face it, $25.50, I mean, if any type of accident with any type of injuries, a trip to the ER, that's not going to be enough money.
No.
So, listen, protect yourself. It's the best thing you can do, and I really encourage people to look at that.
Matt, great job on that question. If you ever want to send us an email question, so easy. Just go to rmlawcall.com, the boys' website, put it in there. Just go to Google, put it in, and we see them every week. We try to pick out the best one for each show. All right, got a question here, Matt. This came in through our great producer, Rachel, and gentleman didn't want to go on air, but says that he had.
It's so late.
Yeah, it is so late, and he's probably
because it's tomorrow.
It is already tomorrow. By the way, happy Holy Week.
You too, sir.
That's all right, there. We're
See
close.
you at church tomorrow.
He says that he had a DUI on his record, and the judge had mentioned to him at the very beginning with his DUI that he might be able to take this DUI off his record with a certain amount of time and some other stuff, and he was wanted to follow up. How would this, is this possible? How would it be possible?
Okay, now, Kenny, that's critical. Yeah, that's interesting. And this was a big, I really think, tectonic shift in DUI law that happened, say 5 or 6 years ago.
Right.
And now you can, for a DUI first, you can do non-adjudication, basically.
Okay.
It requires that you blow in the intoxilizer, right? And there's always been that great debate, do I blow, do I not blow?
Right.
Well, to qualify, you have to blow in the intoxilizer, and then if you do, then if it's a DUI first, you can get non-adjudication. What that means is you get the punishment, but it never attaches to your record. So much so that you never have to say that you were convicted of a DUI. Now you have to pay the fine. You've got to go to the classes. You've got to do the the thing on the car, on the ignition switch, those kind of things.
Okay.
But critically, you can say under oath you were never convicted of a DUI, nor did it affect your driving record. So
that's a big
deal.
That
is a huge deal. That was not the case. There was actually a law, not long ago that said you couldn't reduce a DUI. Remember all that and MAD and those type of things. So anyway, that's a huge shift, and so that's for sure, absolutely.
So if for our caller who came in on that one, would it be a matter of going back to the court that he was originally the judge you originally went in front of, or there's got to be some paperwork on this, right?
There is, and honestly, that's usually something that's handled right then and there.
Oh, okay.
But it is not too late. But I would jump on that very quickly, because once that train gets too far down the station, it is a little hard to call it back and put it on a different track.
I got you.
And honestly, the judges know that, and I have to tell you, the local judges here, they're very good about that. They're not your lawyer, but at the same time, they're not going to let you kind of walk off into something you should.
Sure.
They will say, gee whiz, you may be eligible for non-adjudication. You should probably ask about that.
Right.
So hopefully.
Matt, does he need to call a lawyer on this one, or call his original lawyer, or call the judge's office?
If he had a lawyer, definitely call the lawyer. If not, call the judge's office and get on the docket and kind of see what the situation is. For sure.
Okay.
Yep.
All right, that takes us into our first break of the evening. When we come back, we've got Jim Reeves and tonight's legal brief, plus more of your calls and questions. Matt, the phone lines are getting hot. I mean, it's on. Or tomorrow. Tomorrow, today, all of these.
Happy Sunday, everybody.
Happy Sunday. All right, we'll be right back on LawCall.
Welcome back to WLOX Law Call, broadcasting from the Gulf Coast to the Pine Belt with lawyers from the Biloxi personal injury law firm of Reeves Mestayer, the attorneys for South Mississippi, including Jim Reeves. Known as a tough fighter, Jim has more than 100 cases with a recovery of $1 million or more and is recognized as a top 100 trial lawyer by the National Trial Lawyers Association. Plus Matthew Mestayer. Matthew served as an award-winning judge for nearly 20 years, has recovered millions for his clients, and is deeply involved in community issues on the entire coast. And hosted by broadcaster Ken Flanagan. The show has included over 200 guest attorneys from across Mississippi. This is WLOX Law Call.
And welcome back to Law Call on WLOX and WDAM on this Saturday evening. So glad that you stuck around with us after the 10 Commandments and basketball. Matt will do his Moses impersonation in just a few moments.
As I do every year, Kenny.
Every year. It's a wonderful Easter tradition here on the show. I know y'all can't see him. He is here, though. No, all right, personal injury attorney Jim Reeves explains tonight the particulars of the Jones Act in tonight's legal brief.
Workers who are injured on ships, barges, and other maritime craft aren't covered by workers' compensation. They are, however, protected by a federal law known as the Jones Act. Under the Jones Act, the employer is bound by law to compensate an injured seaman for transportation, wages, and maintenance and cure. Transportation and wages are paid until the voyage is complete. Maintenance and cure are paid until the seaman has reached his or her maximum medical recovery. If the injury was caused by negligence on behalf of the employer, the injured seaman may also be entitled to compensation for pain and suffering, lost wages, and other damages. Generally, anyone who spends more than 30% of their time on a vessel in navigation will qualify as a Jones Act seaman. That includes not only the members of a crew, but others, such as commercial divers. If you suffered an injury that may qualify for Jones Act coverage, contact an experienced attorney to ensure that your rights are protected. That's your legal brief for tonight. I'm personal injury attorney Jim Reeves. Back to you.
All right, thank you, Jim. I don't know if Jim knows, it's just me and you here.
Yeah,
he says back to you.
I know, back
like
to
Dave Elliott's about to show up or something, right?
I don't know.
It's us.
I don't know who's waiting.
I don't know.
Yeah.
Tonight's topic is Ask Us Anything. So we're keeping it loose for you tonight. Any legal topic under the sun, we want to hear from you tonight. And we're going to start off the phone lines, Matt. We're going to go to your hometown, to Ocean Springs, and we're going to talk to Mike. Mike, good evening. What can we help you with?
Hey, Mike.
My wife and I moved here recently from Texas, and a strange conversation came up with our next door neighbors. And they said, have you gotten everything in order as far as your, what do you call it?
Your will,
I'm
Mike?
drawing a blank.
Your will?
It's as far as your wills and some other legal documents that you had in Texas.
Okay.
I said, no, I haven't seen an attorney. And she said, you better see an attorney because some of the documents that you have in Texas are not applicable here. Like you wanted a cremation or you wanted this for your executors and this for your estate. Is that true?
Well, yeah, no, listen, I'm happy to kind of, interesting conversation with your neighbor, by the way, and welcome from Texas. Maybe that, anyway, no, a will done in Texas would be fine here, would have to be probated here. Essentially, it doesn't matter where a will is done, what state is done, but generally it has to be probated in the state where you reside at the time of your passing. So if you were in Mississippi, he'd been here more than 6 months, the will would need to be probated here. But for example, if you still had real estate, dirt, so to speak, in Texas, they'd have to do an ancillary estate. They'd have to do some things in Texas as well. But in and of itself, no, the will is not disqualified because it was done in Texas and you live here. But it is a good time to, we're talking about that, and you and your neighbors are talking about that. Also think about healthcare directives, right? That's the information to your healthcare providers, kind of letting them know what end of life choices you want them to make. If you're brain dead, do they keep you alive? Those kind of things. And a durable power of attorney. That's also kind of a good thing to do. So every couple of years, I wouldn't say every year, but every handful of years, always a good idea to look at your will, look at those kind of things, kind of update those things. Truth is, there's a lot of things you can do to kind of avoid the probate process. Probate process is a little bit expensive. It takes a while. It takes 6 months to a year to kind of complete, but there are a lot of things you can do to really lessen those issues for your family. And having gone through this a lot, a bunch with family, friends, those kind of things, it really helps if you kind of organize those things, because when left unknown and undone, those things, it can cause a lot of family trouble.
All right, Mike, great question there.
Yeah, great question.
And I appreciate what you're saying, because there are areas, when you're talking about Texas law, it is different from Mississippi law in a lot of different ways.
Oh,
but
for
when
sure.
your personal finances and wills and stuff like that, he's in good shape.
He is in good shape,
Okay.
but at the same time, not a bad idea if it's been a while since
Okay.
he's done his will to update it, those kind of things, because what you thought maybe 10, 15 years ago with
Right.
kids and those kind of things, that may change today. So
And
good time to think about it.
I think he needs to watch out for these neighbors.
In the neighborhood, I'm thinking about security cameras.
Yeah,
That's what I would think,
I'm
but
a little weary
I
of
don't
that,
wanna-
Mike. I'm
yeah.
sure they're lovely. I'm sure
Yeah,
they're
I'm sure they
lovely.
are. Very
Okay, this is a new system, so I'm not really sure how I'm going to. Mike, I hope this sends you off in a peaceful way there. And I'm going to try to go to Ryan now. This is brand new. It's like being on the Enterprise here. All right, here we are. Ryan from Gulfport, are you there? Can we help you with anything tonight?
Hey, yeah, so I had a question regarding an open container law I just recently found out about.
Okay, go ahead.
So, yeah, I'm pretty new to the Mississippi area, and I heard a rumor that you are allowed to, I guess, have open container in the car while driving. So I was just on my way to a friend's party, and, I thought might as well have a sneaky road drink before getting there. And I was going like maybe 10 over, cop pulled me over. And I was like, oh, man, this could be bad. And then he sees the open container.
Right.
And he let me off with a warning. So, yeah.
All right, Matt, before you get into this, Ryan,
I feel like you're
Ryan, Uncle Kenny wants to talk to you a little bit.
Ryan,
Uncle
I feel like
Kenny
your father.
wants we're going to get to that in a second. Yeah.
Ryan, I don't want to
Ryan, Uncle Kenny wants you to know that this is a bad idea. Just get to the party, have a good time there, get home safe, no sneaky poo.
Yeah,
no sneaky drinky poo.
Ryan.
That's Uncle Kenny talking to you. Let's go to the attorney now.
No, the other Uncle Matthew with a law degree says, Ryan, bad idea with the sneaky drink before they go to the party kind of thing.
Right, sure.
Listen, I was young once too, many years ago, about the time Moses came out of the river. Yeah. Well, anyway, bad idea, bad things happen. So please be careful of those things. Get a designated rider, get an Uber, but please don't drink, because I can tell you the misery that has walked through my office door that has involved alcohol, and that's where it starts. And I can tell you, and I know you don't want to hurt anybody. I know you hurt yourself, right? But unfortunately,
just curious.
Those things would happen. So anyway, about the open container law, there are some new laws coming out, and in fact, the cities themselves, like for example, Ocean Springs, where I live, they have a downtown kind of entertainment zone, and they have new different rules that apply there as opposed to the state law. So the state law kind of regulates most of the state, but they also allow the cities to, within the borders of the cities, to kind of craft their own stuff. So it kind of depends where you were at the time, what city you were in at the time. There's a general open container law that applies, and then that is, quite frankly, trumped by the individual cities as well.
Okay, so where you are driving could really affect. So, like, for example, if you're in Lucedale like me, that's a no-go all the way around. So just
Really?
know that right now. That's firm.
True.
That's the 11th commandment. So that's in George County. But you make a great point. If you're in a spot in Harrison County or maybe somewhere in Bay St. Louis, it might be a different one. So, all right, Ryan, thank you for the call tonight. Really do appreciate it. Uncle Kenny's going to be looking out for you here all the way around. Okay, that takes us into our final break of the night. When we come back, we're going to try to get another call in, maybe another email question here on Ask Us Anything night on LawCall. Here's that contact information for Reeves and Mestayer. Jim Reeves, Matthew Mestayer. Reeves and Mestayer. There we go. The music's getting going now.
Yeah, kind of.
Yeah, the computer had to jump in
Everyone's
there.
struggling.
Yeah.
It's a struggle.
It's a late night.
It's a struggle.
228-374-5151 is their local number. They have a toll-free number as well. And then rmlawcall.com, which we were talking about earlier. Great place for you to see this week's show, last week's show, email questions, anything you want to know on the website as well. Matthew, the phone lines are getting going.
Gosh.
We had some people staying up with
When
us.
do people go to bed? That's what I want to know.
It's Moses.
Ooh,
brings them
it
in.
is. It does me.
Can you do your Aphrodite?
Moses.
Christmas tradition
I
right
know
there.
it is.
Wonderful.
Yeah, it's
Easter.
not Easter.
Yeah, whatever.
It's
It's all tied.
Yeah,
It's all
it
in
is.
tied.
Anyway.
Shoot, we had a call and now they're gone. That is a bummer because I was just about to go.
Shocking they would
right
leave
there.
us.
All right, let's just go to the email question.
Yep.
We'll go to the email question. We'll get, I think we had Trevor. Trevor was going to call on that one. So here's the question. It comes in from Dave. Matt, this one's a little bit long. My in-laws own a rental house and they hired me to fix some of the loose gutters. Long story short, I fell and tore 2 tendons in my right shoulder. The insurance has been nice so far. They've mentioned paying the medical bills, but during the first interview, but I want to know, can I ask them for wages and something else to help out with expenses? I do not want to hurt my in-laws' income. You could be in a little tricky wicket here.
A little bit, for sure.
Okay.
First of all, obviously, by what he says, there's not a workers' comp situation. That is an on-the-job injury, but he doesn't have comp insurance. And as you know, in Mississippi, if you have less than, I think, 5 employees, you're not required to have it. So you can get it, but you're not required to have it. So in this case, self-employed doesn't sound like you have it. So with damages, all right, they have to be reasonable and they have to be foreseeable. So yes, you can loss of income. That is a foreseeable, reasonable damage in this type of situation. But the law does put limits on the damages you can claim. For example, if you said, oh gosh, I fell, I hurt my shoulder, I was planning to go to Texas and buy a racehorse, and that racehorse is going to win the Kentucky Derby, I need the prize money. No, that doesn't work. But what's foreseeable, the big question is the damage foreseeable? So pain and suffering, yes. Loss income, yes. Those type of things. Loss of quality of life, they call those hedonic damages. If you can't do chores around their house. Actually, interestingly, your wife would have a loss of consortium claim. If you, for example, are hurt and are laid up at the house and can't cut the grass, and she's got to do those kind of things, or do things that you would normally do, she has to do. She actually has a claim as well.
Gotcha.
So absolutely. So loss of income, perfectly fine.
Okay, very good. Note to self: look up hedonic later tonight.
Yeah, go ahead.
Shall I Google that?
After we run
to
Moses again, we'll look that up.
That was great, by the way.
Yeah,
You're on point.
Well,
You're on point.
I kill it every year.
Yeah, you really do.
I do.
Wonderful Easter tradition. Okay, we had a call from Trevor from Loosedale. Doesn't want to go on camera. He is going through. I probably will see him tomorrow.
Hey, Trevor.
He is going through a divorce. His lawyer keeps telling him, be careful what you post on social media. Trevor thinks maybe his lawyer is being a little too conservative and wanted to get your opinion.
He's not, Trevor. Okay. He's not being too conservative. I tell you, social media, cell phones, they've really been great. Video, the advent of videos. Now it seems every case has got video of what happened, and that's fabulous. But no, it is standard litigation 101, and particularly in divorce cases, social media. They'll want your Facebook accounts, emails, your cell phone carrier. So absolutely, I have to tell you, stay out. What your lawyer was going to tell you and did tell you, and he's not kidding, stay off social media. Don't post anything about your divorce, about your new girlfriend, just stay off social media.
Travel.
Well, that's okay. But for example, in an injury case, if you have a video of you, riding across Europe, dare I say, or doing something like that, or playing basketball, and then you're in a case saying, well, I can't do X, Y, and Z, they throw up the video and those kind of things.
Boom.
Oh, and interestingly too, Kenny, it is not uncommon, how sneaky is this, in a case when you are claiming that you are injured for the other side, to get a private investigator to video you, when you're running your errands.
We need to do a private investigator show. Write that down. Hedonic.
I will write that down on my big tablet.
Hey, speaking of, look, and I know this is not the callers right here. Speaking of the big ski case this week with the actress.
I don't know it. Gwyneth Paltrow.
Yes, Gwyneth Paltrow.
Imagine that.
They had all sorts of stuff about the doctor who got hit and then he went to Europe.
You have a lot of free time, don't you?
Well, you know, I try to stay briefed up for the show.
I know you do.
I'm trying to stay.
Oh, well, that was another example
Okay.
of how social media comes into play, and it does, and it you know, obviously in divorce cases for the obvious, but almost in every case now. I mean, I'm telling you, it is standard defense practice 101 that they are going to check out your social profile, your videos, what you're posting, and those kind of things. So you got to be very careful.
And then on the PI stuff, it is legal in Mississippi. We're going to talk about. It's legal for them to track you and to get video of you and audio and everything, isn't it?
Yeah.
Wow.
And I've had them in how sinister is this? Mardi Gras season, right?
Okay.
Following you at a parade and seeing how you doing your parade stuff and catching beads and those kind of things and saying, "Gosh, I thought you were hurt, but look at you here going for the beads." So
Matt, we're getting a ton of stuff off the text message, everything. We got a text real quick here. Wanted to go back over the uninsured motorist. We only got like 45 seconds left in the show, real quick.
Listen, all right, it is the insurance. It's part of the insurance that you have yourself, that when you go to your agent and you get insurance, they will usually want to talk about, well, what would you like, 25, 50? That's the insurance that goes out the door if you cause an accident. What they don't talk about, what you need to know about, is the uninsured or underinsured coverage. That covers you if you're hit by someone else that has no